Hi, everyone. Welcome to a LexisNexis webinar on cybersecurity and the law, protecting privacy in a remote world. So I am Samantha from LexisNexis, and first of all, I'll be showing everyone a very short demo of some of our products that we have at LexisNexis and our solutions in regards to our drafting tools. So just right before we start, we just wanted to let you know a few of our housekeeping matters. Number one, please do note that this webinar is being recorded and the recording will be sent to your email after this webinar. And second of all, there will be some time allocated at the very end of this panel for audience questions. So please do feel free to submit any questions that you may have through the Q&A box and the chat box that you may see on your screen right now. And the panelists will also try to answer as many questions as they can towards the end of the panel. So just right before we start, we also wanted to introduce some of our solutions, which as I'm sharing my screen right now, you'll probably notice that we have what we call our Lexis Plus Hong Kong solutions. And as part of our legal research as well as legal drafting tools, what we're going to be introducing today is what we call practical guidance. Some of the products that some of you might be more familiar with may include our legal research as well as Lexis Analytics, which is part of what we call our legal research side of our research and drafting journey. And on our practical guidance as well as clause intelligence, this is the other part of Lexis Plus Hong Kong, where you'll be able to find things like the templates, perfecter drafting, in all of these jurisdictions that you can see on the screen right now. So this is also one of the upgrades that we have on Lexis Plus Hong Kong, which if you haven't heard, if you don't already know, this is our newest platform at LexisNexis Hong Kong. And on the practical guidance over here, it actually encompasses all of the different Commonwealth or common law jurisdictions that you can see on the screen all in one. So previously, if you were using a platform called Lexis PSL or some of the other platforms such as Lexis Practical Guidance US, this will all be integrated on the same platform. So whenever you're doing any research and whenever you're looking across any of the templates, you will be able to find them across all of the jurisdictions that you have subscribed to over here. So just a bit of background on what our practical guidance is. Essentially, as we mentioned just now, our drafting tool where you'll be able to, as sorted by the different practice areas, find any of the different contents such as the precedents, which we also call templates, practice notes, as well as a lot of the different information that we have in order to make your everyday drafting a lot more direct, and you'll be able to find all of these tools over here. So what we're looking at is the data privacy and data protection module that we have over in Hong Kong. And as we mentioned just now, you can download any of these practice notes as well as the precedents we have over here. And on every one of these precedents, we do collaborate with some of our different authors and expertise on any of this content. And once you're subscribed, you'll be able to download and use these precedents as they are. Uh, on our practical guidance, we also have something called the International Comparator Tool, which does allow you to, especially we know that a lot of our clients or a lot of our users do work in some cross-border transactions. So this is something that we have on top of our practical guidance to allow you to search amongst all of these different jurisdictions and do a comparison so that instead of always reaching out to external counsel in every one of these jurisdictions, you'll be able to just quickly view some of the information in relation to all of these jurisdictions that you can see currently on the screen. And what International Comparator Tool will show you is just some of the questions and answers to all of these jurisdictions that I've selected on my search just now. So this is a tool that will allow you to and help you search for information across whenever you're doing any cross-border transactions over here. And then last but not least, as we mentioned, we do have what we call the international research, especially in the UK and the US, where we do have a much larger collection of many different practice areas in the UK. So especially as we're talking about data privacy today, so when we're looking at things like the EU GDPR, as well as some of the other data privacy regimes, on the UK platform, we actually do have some of the specific information catered towards some of these data data privacy regimes that you can see currently on the screen as well. So this was just a very quick walkthrough of our practical guidance as well as the practical guidance in internationally as well. So we are just going to be starting off with the webinar. And for today's webinar, we are very excited to have Mr. Dominic Y, who is a partner at ONC Lawyers, to be the moderator. So let us just pass this time over to Dominic.
Thank you, Samantha. Good afternoon, ladies and gentlemen. Thank you, LexisNexis, for having me. My name is Dominic Y. I'm a partner with ONC Lawyers Hong Kong. My practice is in civil litigation, compliance, and also covering data protection, privacy, and cybersecurity. I will let my fellow panelists introduce themselves when they speak, and I'm very happy to be in the same panel with my fellow eminent panelists. Now, to start off with, perhaps since I'm in Hong Kong, the current policy of the Hong Kong government in terms of facilitating data flow and safeguarding data security, which implicitly also covers privacy. Now, China's 14th five-year plan states clearly its support for Hong Kong's development as an international innovation and technology hub. So the Hong Kong government has come up with a policy in terms of IT development. I'll be just covering a few of the policy topics that are relevant to today's topic. For example, the government will be reviewing the content in existing laws and guidelines concerning the collection, use, processing, protection, and sharing of data, and explore feasible measures to tackle pain points in specific areas, thereby breaking data silos and removing barriers to data sharing. So it seems that the government would be encouraging more sharing of data locally. And in that context, the Hong Kong government will also be reviewing our own local privacy law, the Personal Data Privacy Ordinance, and explore further enhancement of the Copyright Ordinance with the objective of strengthening protection for personal data and also artificial intelligence, AI, which we will be touching on that, as everyone knows that AI is already here, that is impacting on our lives and workflows. And also on that front, Hong Kong will also be introducing a legislative bill to clearly define in legislation the cybersecurity obligations of critical infrastructure operators to enhance the protection of cybersecurity of critical infrastructure. So in terms of the laws in Hong Kong, either by way of the Personal Data Privacy Ordinance or in terms of introducing a new law in cybersecurity, we are enhancing protection and security in these fronts. I have a feeling that with these changes, there will be some kind of mandatory requirement of reporting if there's a data loss incident. So maybe now it's time to at least get ready if that happens. And of course, I mean, a lot of companies, if you are international ones, of course, you might already have that if you're following GDPR. And on that front, I would just like to share the Hong Kong government also have a policy in terms of facilitating cross-boundary data flow. Last year, they have the Hong Kong and China Cyber Service Administration signed a memorandum of understanding to facilitate the cross-boundary data flow between Greater Bay Area, GBA, and Hong Kong. And they have already come up with new measures that would enhance this cross-boundary flow. Now, GBA, of course, we are talking about the 9 cities in the Greater Bay Area, like Guangzhou, Shenzhen, and probably they also have a lot of data that can be useful for use by, say, Hong Kong, and also vice versa. And also in terms of Hong Kong being an international city, we might also have the need for transferring data out to other jurisdictions. So under this new regime, the government will be having a pilot program, and if one adopt this cross-boundary transfer, then that we will not be infringing the personal information protection law restriction. And with that, actually, if you follow the requirements that would include using of standard contracts and also having some kind of personal information protection impact assessment, then it's possible to transfer data cross-boundary. So on that front, I might just want to start off with asking my fellow panelists. For example, Sharon, understand that you have a regional role. Do you think that this kind of new arrangements would enhance or facilitate the flow and share of data within, say, GBA and Hong Kong?
Thank you very much, Dominic, for the very insightful sharing. I'm glad to see that like Hong Kong government is actually introducing measures to enhance the cross-border to enhance the flow of data transfer between GBA and Hong Kong. And I think that for us, for Tencent, we are an international company and we have a very broad range of products. And then we also like take measures on cross-border data transfer, especially for data transfer like from countries like EU to places outside EU, which actually requires the signing of standard contractual clauses and have some kind of like model data protection mechanisms. And I think before actually talking about cross-border data transfer, maybe I should give more background on what we do from day to day. Say, for example, we as international privacy lawyers, what do we do to make sure that we build a privacy compliance framework for our company and how we apply this in our everyday business. So before I go into all these kind of issues, so I would just like to take this opportunity to maybe just briefly introduce myself at this stage. My name is Sharon. I'm a qualified lawyer in Hong Kong and currently serving as senior legal counsel at the International Privacy and Data Protection Center of Tencent. My job is to ensure that Tencent and its international business actually comply with international privacy laws and regulations, and we adhere to the industry best practices. So apart from that, I also support Tencent's the interaction with data protection authorities and anything privacy and data related outside of the mainland China. So instead of just focusing on like Hong Kong, we also focus on other jurisdictions like on EU, on the US, and any other countries apart from the mainland China. And as you may hear or you may know that Tencent actually provides a very broad range of products to enrich and fulfill everyday needs of our consumers. We provide communications tools. We have like payment services. We also have digital content provided in the form of like music, movies, games, TV, and etc. Tencent is, as you may know, that Tencent is also a cloud service provider, which we offers cloud-based solutions across industries to enable digital transformation. So because of this profile, so we actually is very much involved in data processing. It's not only about like data transfer, but it's also about data processing within these kind of products. So that's why data privacy is actually one of the very major considerations throughout our comprehensive compliance review process of our products. So when we actually work on these kind of like privacy compliance issues, so we actually do actually make sure that we observe our goal, we understand our goals, and then we develop some kind of like mechanism to make sure that everything is compliant. So one of the very major objectives of us is to make sure that we do drive business success. As I know that like Dominic may be supporting his clients to drive business success as well. We as Tencent compliance professionals, we also help drive business success for our companies. So and then one of the very much challenges that you may ask is like what kind of standards that we should use. Like maybe just like what Dominic said, international companies may be already using GDPR standards. We as an international company launching products across different regions, we actually will use golden. We make sure that we comply with some unified gold standards like GDPR in the European Union, and then we also have CCPA in the US, and then also UK Data Protection Act of products is actually launched in the UK. And we also make sure that we adhere to some privacy principles. For example, as like some kind of like GDPR standards principles like legality, fairness, transparency, purpose limitation. And I think many of you may be aware of that already. And then apart from that, we also make sure that we do take note of whether our product team or our business team will actually push back on our standards, like what kind of standards should we take, and then we also understand like what kind of risk assessment approach that we should take when we negotiate with our product team. And of course, sometimes we understand the unified gold standards, but at the same time, we also will make sure that some of the local requirements will be complied with. For example, some of the companies, because our company is actually a very provides products all over the world, so that's why in some of the specific regions like South Korea, we actually have to adopt some of the local requirements, because these requirements are actually suggested or recommended by local authorities. And from time to time, we're actually aware that local authorities, they're actually pushing very hard on that as well. So once we have detailed standards in mind, what we usually do is actually to set our compliance baseline. We, based on laws, based on industry practices, with reference to similar products or services, we set our compliance baseline. And we set our risk assessment standards as well, to understand like what are the standards that we should take, like whether there's any laws or regulations that is related to specific issues, and whether there's any existing enforcement cases as well. And so we use that standards in our day-to-day compliance work. And on that front, well, I can also share more with you, in this seminar, and I want to just to keep a very brief sharing on what the compliance, how do we apply our compliance baseline in our day-to-day work. For example, first things first, we do standardize a format of our privacy-related documentation, like some of the GDPR standard record processing and privacy impact assessment, also privacy policy. And then we also come up with some of the standard operating procedure in reviewing and doing the privacy review. We, from time to time, also do some review on the user interface and specific features of the products. And then from that, we also, like for each product, we also prepare some kind of like documentation, like what I mentioned just now, like record processing, privacy impact assessment, and of course, it's about in relation to cross-border data transfer, and that's where it kicks in. It's when there's any data transfer from one country to another country, or like from one entity to another entity, we make sure that there's standard mechanisms that is protecting, like contractual mechanisms that's protecting these kind of data transfer. Just like what Dominic has just mentioned about cross-border data transfer between Hong Kong and GBA regions. And the Hong Kong government has actually required, like if you want to do that data transfer, you actually have to have some contractual clauses just to protect the data transfer. And for us, as a global company, we do implement those as well. For example, if there's any data transfer for example, it's like data transfer in relation to data subjects in the European Union, from European Union to a third country outside of the European Union, we make sure that the data transfer is actually protected by standard contractual clauses implemented by the European Commission. And if there's any data transfer outside to from a country that's not in the EU, for example, that country has their own like mechanisms for protecting such data transfer. We also implement clauses. We also implement clauses to ask that data transfer to be protected by those kind of like contractual mechanisms. And
I have a question.
Yeah.
I have
sure.
a question, but before I ask the question, let me just remind our audience, participants, that if you have any questions, feel free to put it in the Q&A chat box. But before I ask the question, may I ask if my fellow panelists have any comments on this topic of cross-border boundary transfer of data? If not, then I'll just ask my question. Actually, on all this, one essential requirement is consent. And I would just like to know what happened, or how would you deal with that if you find out that actually you might not have the consent of the user? How would you go about remedying that issue?
I think for us, well, because when we do the privacy compliance review, during the product development process, we of course want to make sure that consent is obtained like before we collect personal data. It's not before we transfer the data, but really before we obtain the personal data from the user. For example, we have a number of like games or applications, like games product applications. Those kind of products, we require users to like acknowledge the privacy policy, which states clearly what kind of data is collected and what are the purposes of data collection, how are they actually processed, like where are they stored, who have access to it, and what are the security and organizational measures protecting the data processing. So we make sure that users acknowledge those privacy policy, and if the legal basis is actually collected based on consent, then we make sure that there's a consent pop-up in a product. We work with our business team to like develop these kind of mechanisms to make sure that we actually have the user's agreement to the transfer of personal data, like to our affiliated companies or to any third parties that we're using their services, so that and of course we enter into contractual arrangements with these kind of like third parties, or we have intra-group data transfer agreement, so that we make sure that all kinds of these kind of data transfer is actually well protected by contractual mechanisms.
Thank you. Maybe I would now move on to another topic that we would like to discuss today, which is building a compliance framework. Perhaps maybe I'll ask Abby on how do we define ownership in the context of data, and what rights and responsibilities does it entail? And how does the concept of data ownership intersect with privacy laws?
Thank you, Dominic. Before I answer a question, maybe I'll just give a bit of introduction of myself. I'm Abby Hearn, and I am a data governance lead at Swire Properties. So basically, I advise companies on their data protection and data governance framework. I have been working on different data governance initiatives in the retail sector, financial service, and also conglomerate sector. Personally, I am passionate about data. And I enjoy helping companies to promote a strong data governance and protection culture. So besides advising companies on their protection framework, I also work together closely with different business units, legal team, and also IT team to achieve this together, to identify and also avoid some potential data privacy leakage risks on that. So this is a topic really close to my heart. And to your question on the data ownership, so first of all, who are the data owners? So data owners, usually they are the senior leaders or executives that they have the resources or authority to manage the data within their domain. So usually they have the general knowledge of how's the data defined, what are the data business rules, what are the standard formats. So they understand how is it used and what will happen if it's not used properly. In terms of their roles and responsibilities, in my own interpretation, to be more clear, they should ensure the accuracy, integrity, and also compliance of data. So what I meant by compliance is actually related to the topic we're talking about today. So in the data protection context, actually data owners, they are responsible for making decisions how and why the data was first collected in our company, how it was stored, where it's going to transfer, even when it's transferred from one business unit to two business unit internally. That's what they should care about also, and also when it also transfer outside the company. So it's really important concept that they have to follow with applicable data privacy regulations. So it could be what Sharon mentioned, the EU GDPR, or it could be PIPL or Hong Kong's PDPR. So really based on the region they are in or based on the type of data they are collecting, they are processing. So I would say putting a compliance culture on how to protect our data is really interrelated to the definition of data ownership. And I would say that having data ownership in place is actually one of the key drivers for our successful data governance initiatives. And it's always the very first step. Very first step before an project implemented, it should be well defined because it ensures a clear line of accountability of how we should manage the data, how to ensure that they are accurate and also they are complete and also up to date.
Thank you.
Thank
Ron,
you.
do you have any comments on this? I know that you have views perhaps on IP-related matters in terms of data ownership and compliance.
Well, okay, just to quickly introduce myself, I'm Ron. I teach commercialization of IP, patent law, and RegTech at CityU, Peking U, and Chinese U, respectively. I've written on AI and law and cross-border data transfer. I even have a co-inventor of a patent on tokenization of to prove the existence of a digital file. My only question to Abby is, how do you keep data is actually very valuable. Have you actually, do you have actually some kinds of mechanisms within Swire to measure, how valuable the data is, or just say, to prioritize data protection in some way?
Yes. So thank you for asking that. That's a great question. So in terms of focusing on Swire properties, I will more based on my general experience and knowledge on that one. So my focus, except the data compliance, I also manage data accuracy. So for data accuracy, actually, there are different controls in place. For example, in a company, maybe they have data quality dashboard, they have data quality reports, some scorecards. So it really back to the basis of what I just mentioned, data owners, how they actually define the data rules, what are the requirements, for example, that certain data type, or what are the data type, and also what are the number of digits. So that's all these requirements help us to build a data quality scorecard with a foundation. So that's how we actually going to have a consistent data rule and finally ensure the integrity of data. So I hope that answers your questions.
That's terrific. A lot of work for you.
Thank you.
So, Ron, do you have any other views or comments in terms of data ownership?
No, actually, but I do have some views on I think protecting data because I'm sure as Abby is and Sharon are well aware of, you can actually accidentally release data, and data is valuable, not just because of privacy regulations, but because you want to protect your intellectual properties, including your trade secrets, and that there are possibilities of losing data through unintentional communications. Now, the other hat I wear is as the director of MakeBell, which is an AI legal tech startup, and so we build smart FAQs at that, among other things, answer questions for people and also analyze, for example, patents. And so since we have some expertise in AI, one of the things we have been building for people are ways to redact data so that certain data doesn't accidentally get transmitted, for example, through emails. But the other place that people don't think about would be in use of AI engines like chatbots. So it's like a ChatGPT, for example, because when you use ChatGPT and insert information, some of that information may go into the training corpus the training data corpus, and then accidentally get released elsewhere. So that's why for example, some patent firms had been reluctant to use some of these products because their fear of loss of novelty of their patents or release of trade secrets, etc. So I think you have to also be careful in this regard with prompting for a ChatGPT or Claude or whatever engine you use. And so therefore, it's also very important to have some mechanism to redact the data to make sure that some sensitive information doesn't get sent out and becomes part of the training data for some larger generative AI.
Thanks. I think that's very important, and we might go into that, but in our discussion. But before I go into that, I see that there is a question in the Q&A. Perhaps we can take that first, as it in relation to the consent. Thank you, Hayden. The question is that GDPR requires consent to be freely given if use of a certain product is conditioned upon the end user giving consent. Then would consent meet the GDPR standard, or would legitimate interest be an easier avenue to comply with GDPR? Karen, would you like to?
Yeah, sure. Happy to take this question. So before I answer this question, I think we need to understand that GDPR actually has provided several legal bases on personal data collection. First one is by contract, second one is by consent, and the third one is by legitimate interest. These are the main legal bases under GDPR. And I do agree with what Hayden mentioned. Is like for consent, it's actually very easy to be withdrawn, because if everything is based on consent, then I withdraw the consent. Then how do we deal with a subsequent data processing? Do we just delete the data, or we cannot actually provide services to that end user anymore? So on that considerations, normally for Tencent, we very rarely rely on consent, or only if such kind of consent is actually on products that is not on data collection that is not necessary to provide the services to the end user. But for data collection which is necessary to provide the services to the end user, we mainly rely on contract. It's contract based on like privacy, what we disclose in privacy policy, or on the like terms of service. So we normally based on contract. For consent, sometimes we do if that kind of data collection is actually not necessary for the purpose of providing services to the end user. For example, in a game, when a user tries to wants to upload their photo just for purposes of generating some kind of avatar, these kind of purposes will be very much likely based on consent, and in that case, will actually require our business team to actually include some kind of like consent pop-up, asking users to give the explicit consent before actually uploading the photo. And in relation to legitimate interest, it's actually, you need to have a very strong ground saying that it's actually collected for the interest of yourself or for the interest of any third party. So for legitimate interest, sometimes we do rely on that, but many of the times it's more related to some kind of features. Say for example, in a game development situation, that would be like providing some kind of anti-cheat function. That kind of functions will normally rely on legitimate interest instead of like contract or consent, because you obviously cannot really require a user to, may not be really require user, but it's very weird to require user to like give their consent, because you have to introduce an anti-cheat function in your game. So and that kind of basis, we normally rely on our legitimate interest. But one thing to note is that when we rely on legitimate interest, we need to have a legitimate interest assessment on the GDPR to make sure that we can rely on legitimate interest for that specific data collection point. Yeah, I hope this addresses your question.
It's very, very clear. But actually, there's one another question specifically for you, Sharon. I have a question for Sharon. Separate consent is required for CBDT activities according to Article 39 of the PIPL. That's the Chinese law. On how can you justify this point relying on the general consent collected for the privacy policy? So would that be something that a specific consent might be required?
I'm sorry that I may not be in the capacity to answer this question because I look at international privacy issues other than those in mainland China. So I don't really have the capacity to address this question because this is specifically on PIPL. So is there anyone in the panel who could take this question?
Well, I think if the requirement is that you need to have a separate consent, and then if you just rely on a general consent, then of course that might not be most safest way to try to justify that you have the consent if there's any issue on that. So I guess it's to be prudent, perhaps a separate consent should be sought just to play safe. And of course, how you do it, that could be a number of ways. And there are also other questions, but perhaps I think those we can maybe wait it to later stage. And perhaps we can now talk about, if my fellow panelists do not object, perhaps we can talk about AI, and since Ron has bring that up also, because actually just last week, I think the Law Society also have issued a position paper on the impact of artificial intelligence on the legal profession. Now, of course, a lot of the business community might already be using that AI or AI-related products, because a lot of the products that we use on a daily basis that the companies have already might be can add on certain AI facilities. And in terms of that, of course, my understanding is that perhaps if, let's say, AI is kind of added to your usual emails or even calendars or messages, then anything that you type on it or you just say, okay, I will have a dinner appointment with someone, that will be captured by AI. Now, how do we deal with potential losses of privacy that may arise through instructing AI? Does anyone want to take that up?
Let me try that first. The obvious way is to redact the information or have an AI redact the information for you. So basically, one solution is to use AI to prevent the other AI from accessing your private information or having this information sent to the wrong source, wrong locations. The other uses, to answer the question in the chat, to ensure that employees do not unintentionally keep company sensitive data, there's obviously you can have some kind of AI to look over and redact information that would be that could be potentially transmitted to other locations. The other more practical way to do it is without AI would be to use some kinds of cybersecurity mechanisms and to ensure that control mechanisms to ensure that certain data does not get transferred onto users' personal laptops. And so obviously one way to do it would be to give just a company laptop to which only company data can be put on that laptop and not transferred to a private system.
Thanks. And I think that's very also important and maybe also useful for law firms if we ever kind of formally adopt the use of AI because of our duty of confidentiality towards clients, and also a lot of the information and data is privileged. And Sharon, would you have any sharing on perhaps on how when you for Tencent to assess and deploy AI technologies in the products?
Yeah, sure. Thanks, Dominic, and thanks, Ron. At Tencent, as you know, the AI is actually a really hot topic right now. So many other companies, they actually introduce products and services that's incorporating AI technologies. So at Tencent right now, so we have been developing, and we have already come up with some of the internal review process and frameworks on AI related products and services. So we will strictly follow the compliance requirements set out by some of the recent developed laws and regulations all over the world. For example, the EU AI Act, which is a very new legislation. We try to strictly follow these kind of like compliance requirements to ensure the transparency and the fairness of automatic decision making and information systems. And we have set out some kind of like questionnaire or checklist so that our product team will know that what do they have to take note of when they are developing these kind of technologies. And we also review any like deployment of AI technologies so that offered worldwide, so that we can understand like how can we make sure that the deployment of AI technologies are actually in compliance with those international AI regulatory requirements outside of the mainland China.
Could I ask maybe then which is there any particular jurisdiction or countries AI kind of requirements that you will follow or adopt?
I think we also just circle back to what I mentioned earlier. It's about having a unified gold standard together with some localized requirements. And of course, we because many of the products they're actually launched all over the world, and then legislations on AI is actually not very mature at this stage, I would say. So we just at this stage we'll just normally follow those unified gold standard, like make sure that it's compliant with GDPR, and if any countries that are planning to launch introduce some kind of AI related legislations, we'll also take note of that. And then if there's any local requirements, we'll also look at that as well. But of course, it's more on like AI legislation is actually introduced in more high risk jurisdictions currently. So many of the local countries, they don't really have these kind of legislations, but I think in the future there could be more and more legislation that we should take note of.
Yeah, I think a lot of places, like even Hong Kong, the Hong Kong government have issued some ethical guidelines on use of AI, and also I think the Law Society in the position paper that I mentioned, they also said that as a matter of actual urgency, the Law Society will also need to formulate some kind of ethical guidelines on the use of AI. Abby, do you have any sharing on this? I suppose in terms of internally, internal policy and also training on employees would also be necessary for use of AI, right? Do you have anything to share?
Yeah, so for AI, it's not my expertise, but then it's for training. I would say that it's really important for employees to slowly develop a compliance mindset. For example, when it comes to AI, what I would think of is what about the compliance of the data actually from AI is accurate, and how long it stays, and when it's going to delete it. So what I concern most is all the general principles in data protection and the training we are delivering. Sometimes we're not trying to train everyone to be a data governance expert. We're more like training them, giving them some data protection tips to our more high level of procedures they might want to embed in their daily operations. So as simple as you can say is, for example, some tips on using email. For example, when you send email, do you really check the recipient of the email? For example, we have Abby Hearn and we have Abby Chan. So it's really common that you might really send to a wrong people. So what I would encourage is the really minor details, because one simple mistake can actually lead to violation of GDPR or other applicable data protection laws.
If I might add to that, in the IP class, that commercialization class I teach, we talk about teaching employees not to disclose IP, and now we also talk about AI as part of that, not just in the sense of developing AI technologies, but also disclosing sensitive IP through AI by chat prompts and other interactions.
Yes, I think that also relates to what Ron you said about accidental loss. That's actually quite common. And maybe I would, in the interest of time, maybe I'll just circle back to Sharon, because you are so popular. There's another question for you. Could Sharon explain more on data transfer agreements, especially intergroup transfers?
Sure. Happy for Dominic to jump in as well, because you also mentioned about data transfer between Hong Kong and GBA places. So for data transfer for us within Tencent, of course, under Tencent there are a lot of entities operating different kinds of products, and many of the times when a product is actually when we have a product, it could be operated by one entity at the same time using other entities' resources. For example, we are launching a game, but then the game is actually using Tencent Cloud resources. So that's why there are actually a lot of data transfer arrangement among entities. And of course, sometimes when we launch a game, say for example, we launch in the European Union, in the countries within the EU, but many of the times we don't really have local servers in the EU places. So that's why we may need to rely on servers or computing resources in other jurisdictions. For example, say like Singapore. And in that cases, there are actually a lot of like data transfer arrangements within these kind of between entities and between jurisdictions. So in that case, we normally have intergroup data transfer agreements among different entities. And that data transfer agreements, as I mentioned, we do and introduce clauses talking about, for example, if it relates to GDPR regions or like UK, etc., we will introduce incorporate standard contractual clauses published by the European Commission. And then for other countries transfer from one country to other countries, then we'll also make sure that the model data protection data transfer mechanisms actually comply with in accordance with the laws of the exporting countries. So for that one, I'm not sure if this can actually address the question on data transfer agreements, but I think it's actually quite important because as you may know that say for example in the EU, if there's any data transfer outside EU to places which does not have adequate level of protection as regarded by EU, for example, like many of the countries, like there is actually a list of countries which EU has regarded as having adequate level of protection, but outside of those jurisdictions, any data transfer may need to be protected by some transfer mechanism like transfer impact assessment, etc. And so I think data transfer, when we do it, we need to take extra care, and we need to make sure that there's contractual clauses protecting these kind of data transfer. See if Dominic has anything to add on this.
Yeah, I agree, because it also depends on a lot of things, like what exactly is the data, and I mean, even just for personal information, some jurisdictions, they might have another category known as sensitive personal information, which then you require more stringent kind of requirements, separate consent, that kind of thing, and depending on the things that if you're allowed, you got the consent, then you still might need to go through the use of standard contract clauses or even some assessment by the regulators. But if it's talking about from Hong Kong to outside, and our own PDPO's section on the cross-border transfer has not come into effect. So the main thing is to make sure that it's for the proper purpose and you get the consent. Let me see. There is one question by Paul Fong. Based on the Cyberport and Consumer Council's hacking cases, very unfortunate. Personal data is a subject matter for ransom or ransomware, I suppose. What are the practical measures recommended for discharging corporate or organizational duties on cybersecurity, apart from redacting personal data that may be practicable sometimes? Maybe I'll go first on this. I think if one is talking about personal data, of course, there's the data protection principles that will apply in Hong Kong, and one of that is to ensure that the personal data will be secured and not fall to the data user have to take practical steps to ensure that there will be no data loss in terms of either hacking or accidental loss. So what is practicable will of course depends on maybe the data user. If it is a sizable company, then it's expected that they should have the resources and expertise and also the will to make sure that there's good enough systems in terms of firewalls and cybersecurity measures to prevent things like ransomware or hacking. So it depends. Again, I'm sorry for the kind of lawyer talk. But Ron, do you have any sharing on this front in terms of the question?
Actually, let me answer that from a my past experience in computer forensics. Basically, there are always a lot of ways to hack into systems, and systems are always being hacked into. One way is also to ensure you actually have very good backups, and from a backup standpoint, it means not just putting something, a backup site next to the servers, but actually putting one elsewhere, so that and also making sure that some of these backup sites are actually separated from the internet, such that they are well protected against the cybersecurity attack, and that you could actually go back and visit the information again. In terms of ransomware attacks, unfortunately, they are getting more sophisticated, and you can actually buy a lot of the ransomware tools online. So they'll just be more and more active. So it's just a matter of cybersecurity threats. Dominic, if you don't mind, can I just go back and circle back to the data issue, and also sort of indirectly answer the question on whether you expect privacy commissions around the world to tighten laws? I think I'm not going to answer that question directly, but I think one of the areas you have to look at would be the data that's on some of the lawsuits that are going on with regards to AI systems, and whether or not these may have an impact on data regulations. You had the laws, you had the robo-debt scandal in Australia. You also had the current Cigna lawsuit in California. Now that while that is more focused on the algorithm, there is a significant data component to it, and there's an issue on the training data used. And if there are problems, depending on how the lawsuit goes, there may be implications for data and data governance and data curation in this regard. So I think while this is not going to have an immediate impact, I think it's something that people should be aware of, and that it might be worth keeping on the radar just in case something happens.
Yeah, thanks. Yeah, thanks. I also want to add to this question. apart from like AI legislations, I think one of the growing trend on legislation is actually on children's privacy. It's because right now there are more and more applications or games that they can be accessed by children. And with the prevalence of AI, definitely there are more and more chances for children's data to be collected by these kind of applications. So and actually there are countries like the US, also UK, they have actually introduced a number of like children's specific privacy laws, like the COPPA, the Children's Online Privacy and Protection Rule, and the UK Age Appropriate Design Code, and the California Age Appropriate Design Code as well. So I think for children's data, we need to make sure that we have the lawful basis to collect that personal data, and then I'm sure with these things in mind, with these like the prevalence of AI and more data processing in mind, I'm sure like probably privacy commissioners around the world will take a closer look at how to protect children's privacy. And there could be more and more legislations in different jurisdictions on this as well.
Thank you. Abby, you have anything to add on this? What do you think of the outlook for 2024?
Great. So actually, I do not have much to add to that, but I would say that for the culture-wise, I think data governance is more a hotter topic. So I would say that from compliance and also minor steps are really important. So for example, how do we have a mature data governance framework? How do we define ownership, and do everyone aware of their roles and responsibilities also matters. So that would be my goal. And also hopefully everyone, if they are more interested in data governance, feel free to ask me anything. This is a really topic I'm really interested. So feel free to give me a message anytime.
For myself, I think in terms of whether there will be tightening laws and regulations on data, I do think that there will be, because if you look at these days, just this morning, we have the news about our chief executive's video being manipulated by deepfake into trying to get people to invest in certain products. And there have been a lot of other deepfake manipulation to make people think that, oh, that person or celebrity is saying something or vouching for certain things. Now, of course, that is a very big issue, not only to that might affect things like elections, and also that cause a lot of trouble and reputation loss, and also might be a kind of harassment on the persons whose image has been misused. So how do you deal with that kind of issue of AI or deepfake? I do think that there would be some laws, because I don't think the criminals will stop. If they are able to try to misuse all these, and then they are able to use that to scam people, and we know that there are so many scams these days, and also that is probably something that is also tied in with data governance and cybersecurity.
And
okay.
you also have personality and publicity rights laws in certain jurisdictions that would also be relevant in that case.
Yes. So I think we are up to the hour, and if does anyone have any final words on today's topic?
I think.
Okay. If not,
sorry.
Ron, go ahead.
I was going to say, I think it's been a pleasure to be with such knowledgeable and smart people.
Thank
you. Thanks, Ron. And I'm also very glad to speak at this. Yeah, I'm also very glad to speak at this panel, and I'm happy to take any questions offline, and feel free to connect after this seminar.
Yes. Thank you.
So
thank you,
likewise.
my fellow panelists.
So much.
Thank you, Ron, Abby, and Sharon. Okay, I think we are done. Okay, see you. Have a nice day. Bye-bye.
Bye-bye.
Thank you, everyone. Thanks
Bye.
again for having me.
Bye bye.
Bye.
Bye.